Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in Republic of Sudan versus Harrison, certiorari to United States Court of Appeals for the Second Circuit. Argued November 7, 2018. Decided March 26, 2019. The Foreign Sovereign Immunities Act of 1976, FISA, generally immunizes foreign states from suit in this country unless one of several enumerated exceptions to immunity applies. 28 U.S.C. sections 1604 and 1605 through 1607. If an exception applies, the FISA provides subject matter jurisdiction in federal district court, section 1330A, and personal jurisdiction where service has been made under section 1608. That's section 1330B. Section 1608A provides four methods of serving civil process, including, as relevant here, service by any form of mail requiring a signed receipt to be addressed and dispatched to the head of the Ministry of Foreign Affairs of the foreign state concerned, section 1608A3. Respondents, victims of the bombing of the USS Cole and their family members, sued the Republic of Sudan under FISA, alleging that Sudan provided material support to al-Qaeda for the bombing. The court clerk, at respondents' request, addressed the service packet to Sudan's Minister of Foreign Affairs at the Sudanese embassy in the United States, and later certified that a signed receipt had been returned. After Sudan failed to appear in the litigation, the district court entered a default judgment for the respondents, and subsequently issued 3 orders requiring banks to turn over Sudanese assets to pay the judgment. Sudan challenged those orders, arguing that the judgment was invalid for lack of personal jurisdiction, because section 1608A3 required that the service packet be sent to its foreign minister at his principal office in Sudan, not to the Sudanese embassy in the United States. The Second Circuit affirmed the below decision, reasoning that the statute was silent on where the mailing must be sent and that the method chosen was consistent with the statute's language and could be reasonably expected to result in delivery to the foreign minister. The Supreme Court held, reversed and remanded, most naturally read, section 1608A3 requires a mailing to be sent directly to the foreign minister's office in the foreign state. A letter or package is addressed to an intended recipient when his or her name and address are placed on the outside. The noun address means a residence or place of business. Webster's Third New International Dictionary. A foreign nation's embassy in the United States is neither the residence nor the usual place of business of that nation's foreign minister. Similarly, to dispatch a letter to an addressee connotates sending it directly. It is also significant that service under section 1608A3 requires a signed return receipt to ensure delivery to the addressee. Several related provisions in section 1608 support this reading. Section 1608B3B contains similar addressed and dispatched language, but also says that service by its method is permissible if reasonably calculated to give actual notice. Respondents' suggestion that 1608A3 embodies a similar standard runs up against well-settled principles of statutory interpretation. See Department of Homeland Security versus McLean and Mackey versus Lanier, Collection Agency and Service. Section 1608B2 expressly allows service on an agent, specifies the particular individuals who are permitted to be served as agents of the recipient, and makes clear that service on the agent may occur in the United States. Congress could have included similar terms in 1608A3 had it intended the provision to operate in this manner. Section 1608C deems service to have occurred under all methods only when there is a strong basis for concluding that the service packet will very shortly thereafter come into the hands of a foreign official who will know what needs to be done. Under 1608A3, that occurs when the person who receives it from the carrier signs for it, interpreting 1608A3 to require that a service packet be sent to a foreign minister's own office rather than to a mailroom employee in a foreign embassy better harmonizes the rules for determining when service occurs. This reading of 1608A3 avoids potential tension with the Federal Rules of Civil Procedure and the Vienna Convention on Diplomatic Relations. If mailing a service packet to a foreign state's embassy in the United States were sufficient, then it would appear to be easier to serve the foreign state than to serve a person in that foreign state under Rule 4. The natural reading of 1608A3 also avoids the potential international implications arising from the State Department's position that the Convention's principle of inviolability precludes serving a foreign state by mailing process to the foreign state's embassy in the United States. Respondents' remaining arguments are unavailing. First, their suggestion that Section 1608A3 demands that service be sent to a location that is likely to have a direct line of communication to the foreign minister creates difficult line-drawing problems that counsel in favor of maintaining a clear, administrable rule. Second, their claim that 1608A4, which requires that process be sent to the Secretary of State in Washington, District of Columbia, shows that Congress did not intend Section 1608A3 to have a similar locational requirement, is outweighed by the countervailing arguments already noted. Finally, they contend that it would be unfair to throw out their judgment based on petitioners' highly technical and belatedly raised argument. But in cases with sensitive diplomatic implications, the rule of law demands adherence to strict rules, even when the equities seem to point in the opposite direction. The decision below is reversed and remanded. Justice Alito delivered the opinion of the court in which Chief Justice Roberts and Justices Ginsburg, Breyer, Sotomayor, Kagan, Gorsuch, and Kavanaugh joined. Justice Thomas filed a dissenting opinion. Thank you for listening. If you'd like to reach the podcast, we can be reached at rhodesscholar80@gmail.com. That's 80 and RO80.